I think we're ready. Good morning, everyone. Welcome to the Maryland Public Service Commission's administrative meeting, February the 21st, 2018. Let's begin with our draft minutes from the February 14th meeting. I'll move to approve the minutes. Is there a second?
Second.
All those in favor signify by saying aye.
Aye.
Minutes are approved. On to our consent agenda.
Mr. Chairman, before we begin the consent agenda, I just want to announce today that on the administrative agenda, items 2 and 3, which are filings from Vista Energy Marketing, we're going to defer those items until a future administrative meeting.
Okay.
Item number 1 is MedImmune LLC filed a request for approval to construct a Type 2 generator in Gaithersburg, Maryland.
Any questions on the consent agenda? If not, do we have a motion?
Yes, Mr. Chairman. I move that we approve the construction of the requested generator that the Commission finds meets the requirements for exemption from the CPCN requirement as set forth in Section 7-207.1A of the Public Utilities Article.
Is there a second? All those in favor signify by saying aye.
Aye.
Motion carries.
Next item on the agenda is item 4. It's MP2 Energy NE LLC filed an application for a license to supply electricity or electric generation services in Maryland.
Good morning, Mr. Chairman, Commissioners. Kenneth Albert on behalf of staff. This item addresses a request by MP2 Energy NE for authorization to operate as an electric supplier for commercial industrial customers in the service areas of all utilities that allow suppliers to operate. Their management has significant experience in the industry. In 2017, Shell Energy, a major energy company, actually bought MP2 and its affiliates. We did check on their performance in the many states in which MP2 and its affiliates are active, and the performance was satisfactory. We've looked at their training materials and website, and those as well seem satisfactory. On the basis of this, staff recommends that the Commission authorize MP2 to operate as a supplier.
Thank you. Questions for staff? If not, do we have a motion?
Yes, I move we grant the company a license to operate as an electricity supplier in Maryland for the customer classes and service territories applied for and recommended by staff, and direct the company to file notice with the Commission within 30 days of any changes to the information in the application.
Is there a second? All those in favor signify by saying aye.
Aye.
Motion carries.
Mr. Chairman, next item on the agenda was originally it's from Deca Energy, Inc. It was originally an application for a license to supply natural gas or natural gas supply services in Maryland, but the applicants requested rehearing of the Commission's order.
Yep, you can feel free to take a seat at the council table. Good morning, Mr.
Thank you.
McGee.
Good morning, Mr. Chairman and Commissioners. For the record, James McGee with Alexander and Cleaver on behalf of Deca Energy, Inc. Deca Energy appreciates the opportunity to provide comments based on the request for reconsideration that it filed, and we appreciate that opportunity. After yesterday, I'm sure there's lots of questions as to, well, why would we approve anything Deca filed about supplier consolidated billing when we had many questions come up yesterday that seemed like need to be resolved first. But we're going to explain today the great amount of differences between yesterday and the request that we have today. First, very briefly on the background of Deca Energy. Deca Energy is a company that was formed in 2012. They started operations in 2013 in the Washington Gas Light Service Territory in the Commonwealth of Virginia and in the District of Columbia. And what they're seeking to do here in Maryland is what they're doing in those two jurisdictions, which is to send a bill directly to the customer instead of Washington Gas, and to use their particular product, which is a flat billing product called Comfort Zone, where it's a flat fee that includes the commodity charge, the supply charge, the distribution charge, taxes, fees, everything that a customer would pay. We had submitted a sample bill on Friday that goes over some of that, and we'll turn to that in a minute. But ultimately, the gist is whatever charges that Washington Gas has for that customer based on the gas usage that month, Deca gets a copy of that rather than the customer. They then determine the amount of money that the customer would have to pay Washington Gas, and the difference from the contract price that Deca has with the customer would then be Deca's charges. So for example, if there's a flat fee of $99 per month that the customer would have with Deca, and the bill is $66 from Washington Gas, including everything, DECA's commodity charges ultimately would be $33 for that month. If there's a high usage month in the winter time as a result, and it's $95 for all the charges for Washington Gas, then under that scenario, DECA gets $4 a month for that charge. So this type of product is a budget billing type of product that certainly during the winter time, the customer is going to receive less charges from DECA within that full $99 example. And in the off-peak times in the fall or the spring, there may be more of a commodity charge to DECA. But what we proposed in the bill, and pursuant to the COMAR regulations that OPC had concerns about, we went through and we itemized everything. So the customer sees exactly what they would get. They see exactly how many therms they use. They see the charges for distribution by Washington Gas. They'll see the taxes, everything else, and then they'll see what DECA charged to make that bill whole, to make it $99. So the customer is paying that same amount every single month, regardless of how much energy is used. Okay. We see great differences in what DECA is offering than what is being offered in the petition that you heard yesterday. And one of the major reasons for that is that we're talking about just one product that DECA is offering. Also, Washington Gas already has supplier consolidated billing in their service territory, and their affiliate Washington Gas Light Energy uses that. They've used that for about 20 years or so. They have 15,000 customers as of 2014, at least. That's the last number that we had seen. And they don't have all of the same concerns, really any concern that we're aware of, that the other utilities in Maryland do, because they'd be starting from scratch. Washington Gas is not. So some of the differences also include the cost to implement and the cost recovery, and that's a big issue talked about yesterday. That doesn't exist here. Washington Gas does not have to spend any money to allow DECA to do what they need to do. Nor does DECA, because they already have that system in the other jurisdictions. There's no then issue of cost recovery, who has to pay this, because there are no additional costs that the utility would have to incur. Second, regarding termination, DECA, as we mentioned yesterday, does not want to terminate customers and put them, give them no ability to receive any type of gas from a different supplier or the utility. They would just return to SOS service for gas if there was a non-payment of DECA's charges. So about that non-payment, if DECA, again under that $99 example, if they're paid $50, then the whole $99 still goes from DECA to Washington Gas. And DECA tells the customer, hey, customer, you only paid $50, you still owe $49. If that continues for a longer period of time, then DECA informs them that unless you pay, we're going to terminate you from the contract with DECA. But they would not, again, the gas wouldn't be shut off. They would just return to Washington Gas at that time.
Mr. McGee, so
Yes.
are you saying that if they only receive $50 but they owe Washington Gas $70, that DECA would pay the entire $70 to Washington Gas?
Correct. DECA would pay the full thing and deal with collections on their own directly to the customer. And if it gets so great where they can't collect, then they'll terminate their contract with the customer.
So this is completely different than a purchase of receivables type of situation. It almost sounds like DECA becomes the customer of WGL or maybe a co-signer of sorts. Is that what the business model
Yes,
is
it's
about?
kind of like a reverse purchase of
Okay.
receivables, where DECA would purchase the receivable of the utility. So DECA would make whole Washington Gas in every scenario, even if they don't get paid by the customer. That's the risk they take when offering this type of product.
Okay, and then so you say there are no changes in the billing system. So the bill then of the customer goes directly to DECA. Is that how this works?
So Mr. Michael Sergeev is here next to me. I should have introduced him before. He's the president of DECA, and he might be able to talk to more specific operational questions. But my understanding is that Washington Gas would transmit electronically the charges, the amount of therms used and the charges they have for that customer. Nothing would go to the customer in terms of a bill from Washington Gas. DECA then calculates what their commodity charge would be based on that because of this flat bill, and then sends the bill to the customer. So the customer only gets one bill, which would be the bill from DECA that includes everything.
Okay. Thank you.
Okay. Another item that Washington Gas is not concerned about is the bond. There was talk about security and the bond, and Washington Gas had testified in the last administrative meeting in the summer that the bond they have is sufficient, that DECA has with them, and they always have the ability to increase the bond or security if they need to. So they didn't believe that, based on what DECA was doing or wanted to do in Maryland, that they needed to increase that bond. And also there was a question about outreach of existing customers. Well, all of a sudden they're going to get a new bill from a new entity, the supplier, and not the utility. DECA has no Maryland customers, so there's no outreach that would be needed to Maryland customers to say, hey, you're going to get a different bill from a different entity, because they have none. So once they enroll customers in Maryland, they're going to get the DECA bill, and it'll be a clean start for them. I wanted to go through the other commitments that DECA had made based on concerns that the Commission raised and Office of People's Counsel raised during the administrative meeting. For ease of reference, the list that I'm going to talk about is on page 8 and 9 of the request for reconsideration. So several years ago, when the Commission first heard about this issue, and it was discussed yesterday, where the Commission recognized supplier consolidated billing as something authorized and allowed. They recognized in that order, it's order 77245, that Washington Gas does provide this type of service, but no one else wants to do it. There's no supplier interest at the time, and you heard yesterday there is now the time. But Washington Gas, unlike the other utilities, they do have provisions about supplier consolidated billing, and they're active with it. The Commission in the order listed several items that said, well, if we did go down this path, there should be minimum requirements in the contract or bill, and so we've included all of those in the submission that we made on Friday, in both the contract and the terms and conditions and the bill that we'd have that mirror what the Commission asked for. So all of those things are included in our submission that comply with that order. Number 2 is about the termination. We already talked about that. The number 3 item, that DECA is not going to take any prepaid security deposits. So some suppliers do, and they can check that box when they apply. DECA chose not to check that box, and so we're not going to do that. Number 4 is the sample bill, which I've already talked about. Number 5, there was a question about MEEP funds and what happens for customers who get assistance from the state. And we've learned in discussions with Washington Gas of how they do it with their affiliate, Washington Gas Light Energy. And they would do the same thing for DECA. So basically, from what I understand, the payment on behalf of the customer would be given to Washington Gas. Washington Gas would then go into the system of DECA. They'd have the ability to do that and post that payment to DECA. So DECA, on a monthly basis, would see the charges that the customer would owe to Washington Gas, the credit that they get to the Washington Gas bill, and DECA would use those 2 items and subtract it from that flat rate of the $99 in our example. So the customer would get credit from MEEP. They wouldn't have to pay DECA the full amount and then get a refund. And we honestly weren't exactly sure how it was going to work when we were before you before. But we do now, based on further discussions with Washington Gas. So it would be a very similar construct as what would happen today, even if they were not, they didn't have a supplier consolidated bill. The 6th item, we agreed to provide, just like all suppliers, provide marketing materials to the Office of People's Counsel and staff before we would go forward and market Maryland customers. That was also included in the packet that we filed on Friday. Number 7, DECA is not going to charge a termination fee. Suppliers are free to do that. There's no rule saying that they cannot, and that's a competitive advantage or disadvantage based on what that supplier chooses to do. We're informing the Commission we have no desire to do that, haven't in the past, and don't want to charge that. So if you wanted to condition some type of order approval that says we can't, we're fine with something like that. Number 8, there was also discussion about Empower Maryland. Well, what if you have this flat bill? What if there's energy efficiency improvements that are made, and now the customer is using less money or less therms than they were using before? What happens? Are they allowed to get out of their contract? DECA's practice first is that the customer has the ability to make a change to the contract based on the energy efficiencies that are made. So if they could show that, look, as a result of Empower, I'm now using less, and it's not a good deal, they'll get out of the contract if they want to, or renegotiate with DECA for some other amount. And the last item we mentioned is a standard practice for DECA, where if there is an increase in therms, so the reverse, not the decrease from Empower, but an increase, this is a binding contract. DECA is not going to kick them out if all of a sudden DECA thought they were going to use a lot less, or maybe they did historically and then they had a big spike. That's in their terms and conditions, which we submitted. For 2 exceptions, though. If there's a natural gas pool heater or an outdoor heating system or natural gas power generator, if those items are installed after the contract and that results in a spike, DECA has the ability to get out of that contract. But otherwise, they would not. Any questions about
Mr.
those?
McGee, I think this came up last time, but I'm just looking at this bill, and it talks about that I guess DECA may cancel this agreement by giving a 30-day written notice. So, what happens if a customer signs up in November? This is this is like an annual, right, flat monthly charge, and then in April they decide, hey, this was a great deal for the winter, now I want out. I mean, can they just get out, or are they liable for the full year's kind of commitment?
They are able to get out of the contract. There is a provision in the terms and condition where that they can cancel by calling DECA and notifying them. So that's a risk that DECA takes. In addition to those commitments, which a lot of them do mirror what COMAR would require with that order that I mentioned, there are other things that came up yesterday that we wanted to address. Commissioner O'Donnell, you referenced RM43 and a COMAR provision about calls that would be received, and making sure that the suppliers were okay with adhering to the high call standards that the Commission has. And the standard that I looked at was in COMAR 20.50.12.18, which talked about 75% of the calls have to be answered within 30 seconds, and 5% or less of those calls could be abandoned. So there can't be an abandoned rate higher than the 5%. And DECA's fine with agreeing to those provisions in COMAR.
Can I ask you a question about that?
Sure.
I appreciate that DECA's fine with agreeing to that, but there's no regulatory framework for us to require DECA other than the order. There's no kind of standardized regs that would point to that. It just kind of makes sense. You agree? I think so too, but...
Well, I would anticipate you'd put it in the order and say DECA is allowed to provide this service where they are able to send a bill to the customer, and you can even include it that it could only be related to this flat fee product that we talked about if you wanted to restrict it to that, because that's their intention. And you would include all of the things we mentioned if you wanted, that these are the conditions upon which DECA can provide this type of service in Maryland. You can reference this COMAR provision, even though it says utility on it, and say DECA has agreed to, or we're requiring DECA to comply with this. There's an annual reporting period that's included in that provision, so DECA's submitting to the Commission to do that. So I think you can order that, and we're fine with it.
Agreed, and I appreciate that. But what I'm really asking is there's no existing regulatory framework other than us including it in an order by reference. That there's nothing in the supplier consolidated billing or consolidated billing section of COMAR that talks about that, right, other than what applies to the regulated utilities.
I think that's correct.
Okay, all right, very good, thank you.
You're welcome. There was a discussion.
Could I just also on the phone call issue? How do you currently handle in D.C. and Virginia emergency calls? If someone calls in and because they smell gas, what is how do you deal with that type of a customer call?
That was going to be actually my next point. And on the bill, no, that's fine. On the bill itself, there is a provision. Actually, it's on the very bottom of the bill on the third page. If you smell gas, call, and that's actually Washington Gas, their number. Maybe we should make it clear, call Washington Gas or 911. The number's on there too. But how they answer, and Michael can chime in, is to, if they do get calls, refer them to the utility. That's not something that we would want the customer to directly call DECA about, because there is then a delay to whether it's transferring them or telling them to call this other number. We want to be clear that DECA provides the bill and services related to that, but if there's a gas leak, Washington Gas is the one that should handle that.
Okay, sounds good. I guess what I'm going, since we heard a lot yesterday about developing this relationship, I mean, if you're successful, I would assume that immediately if someone has a gas issue, they will be calling DECA. So how quickly do you handle that type of an issue? If someone calls, I'm very concerned I smell gas. Well, how is that handled if the call is received by DECA?
I mean,
Now,
our call center is conditioned to direct any what we call molecules issues, gas smell,
Okay.
disconnect, reconnect, directly to Washington Gas immediately. So they have it as a speed dial, and they just transfer and say, we have this customer calling, but I think it's more your question. So, but it's immediately they transfer the call.
very good. That's what I wanted to hear. Thank you.
One other question yesterday was regarding dual billing and what if we go a dual billing route? Do we really need to do it this way? And the reason that DECA cannot do a dual bill is that there's no way, even though Washington Gas has the ability to allow supplier consolidated billing, they don't have a mechanism currently that would allow DECA to look at the charges somehow before the customer would get it. So DECA does have the ability to certainly estimate what the charge may be based on the therms, but let's say you're a couple dollars off, and the customer then would get a bill from Washington Gas, because it would be reverse, right? DECA would have to either send their own bill, or if Washington Gas included it under one bill, DECA would have to guess at what Washington Gas's true charges are. So if you either take the two bills and add them together, they're not going to be $99. Maybe they're $103. And then the customer is like, wait a minute, we just had an agreement that this is my flat rate, and I'm not getting that flat rate. So either under the utility consolidated bill or a dual bill, DECA can't meet its promise to the customer that you will only pay this flat rate of $99. So we explored it. Certainly, if that was possible, DECA would want to do something like that, but it's not physically possible at this time. And in addition, obviously, DECA does want to have a relationship with the customer and establish that, and have the customer understand that DECA is able to meet its needs and things of that nature. But the dual bill, unfortunately, doesn't allow DECA to provide this product that it wants to provide, the flat bill product. The Office of People's Counsel sent a letter and had a couple issues. One was regarding MEEP, which I've talked about already today. One was involving the statement that that COMAR requires the contract to have a signature on it. I looked at that COMAR provision, and that's if there's a telephone solicitation. So if you talk on the phone with a customer, you then have to send a customer something that the customer signs. DECA doesn't use that type of marketing. They don't do telemarketing like that. But also, even if they did, we think the contract that they've provided on Friday does have that. And it's kind of in the middle of the packet where the customer has the rate that would be charged, and there's a line that the customer would sign after they check what they'd want, and the item there also incorporates the terms and conditions that DECA has. So number one, we don't think that would realistically apply, because it's going to be for the telephone, and number two, they're going to ultimately agree to this anyway through what DECA sends.
Mr. McGee,
Yes,
what is DECA's primary method of customer acquisition?
direct mail. They do not do any door-to-door sales whatsoever. Correct me if I'm wrong, but I think they tried that early on and didn't like the experience, didn't like to have agents out there that they can't 100% control the message, which what they can do with direct mail. So they exclusively, I believe, communicate via direct mail.
So to be clear, then, it's a solicitation in the mail
Correct.
through how would they acquire the customer address, name, and information in order to send the solicitation?
Without diving into the competitive advantage my client
course.
may have, I'll let my client.
So in Maryland, the names and addresses and phone numbers of customers who did not opt out from receiving solicitations are released to suppliers twice a year. And then based on that information and proprietary models that we have to correlate house sizes and year it's built and the geographical location, we come up with the price. In other jurisdictions, we have different ways, but in Maryland, it's primarily from the address and then whatever tax records we find for this house.
Thank you.
OPC's last specific concern was that DECA may need a waiver of a certain COMAR provision, and they, in a footnote, say that what the COMAR provision states, that the supplier's marketing material must disclose a price that, in really Part B, quote, the price quoted does not include any tax, utility distribution charge, or other utility fee or charge. We agree. We would certainly need that waiver because this is the opposite of what we're proposing. We're proposing that the price that we quote, the flat fee, does include absolutely everything. But the bill itself that will be sent will show the breakdown of what those are. But you're right. We would, or OPC is right. We would need a waiver of that particular COMAR provision. And in case I didn't make it clear, but before, and I know there were questions last time about the taxes. Well, what if Montgomery County has a tax, or there's other taxes that need to be paid? How would that work? The same way as it does now. So DECA pays Washington Gas the bill that the customer would owe, that full $99, and Washington Gas pays the taxes and everything else they would pay, just like they would if the customer paid that same amount of money. So there's nothing that DECA would do in terms of taxes. Nothing would change under the current construct. I wanted to pass out a couple things that we were able to get recently that I think supports what we're saying about what Washington Gas allows other affiliates or anyone else to do in terms of supplier consolidated billing. So I'm going to approach if I could, please. The first one I passed out is just a sample or redacted, not really sample, but redacted bill from Washington Gas. And the highlighted part just indicates that this person, this customer, is leaving Washington Gas's SOS and going to the supplier consolidated biller. And the second item that I passed out was a part of a PowerPoint from the 2016 Gas Suppliers Conference in September of 2016. And the first page talks about the different billing options: the dual billing, utility consolidated billing, supplier consolidated billing. And the second page gives more detail about supplier consolidated billing. And this is exactly how DECA would perform as well. So the first talks about when customers enroll, there's a zero balance that they would have with that supplier consolidated bill. If there is a amount that's owed to Washington Gas before DECA would become the supplier, that's something between the customer and Washington Gas. It's not DECA or other suppliers wouldn't somehow take on the bad debt that the customer has already with Washington Gas, just going forward. And it also makes clear in the second section that that customers that drop from the supplier would be returned to the utility or a new supplier, and they'd have a zero balance with Washington Gas. So it just confirms what we're talking about and what we'd want to do here and what they do in other jurisdictions, that the customer does not face a fear of disconnection as a result of their interactions with DECA. One other thing I wanted to mention about the Office of People's Counsel, and you'll hear from them later today, not only about this, but also their view overall on supplier consolidated billing. But for this case, they referenced a case-by-case basis, that if the Commission approves this, yes, Washington Gas Light Energy does do this type of service. If you allow DECA to do it, then you're going to have to allow someone else to do it, and we'd agree to that. But that's what you do all the time. You approve what a supplier does on a case-by-case basis now in terms of giving them a license to operate. So we understand you did already give DECA and you granted that license, but in reality, they're never going to use it if they don't have the ability to give this type of product, to the customers in Maryland. That's their sole business model to date. So we think that if someone did come forward and has similar requests and gives similar assurances to the Commission, and you required an order, then it would make sense to me you would approve someone. It comes after DECA, even if you haven't gone through the full regulatory process with the global supplier consolidated billing that was discussed yesterday.
Mr. McGee, I don't know if Washington Gas is here today. I know we brought them up last time. Do you know if they have agreed to implement this if the Commission approves it?
They have. They've signed a document. Mike Klein could talk about more details, but there's a billing agreement or addendum, or there is something that they've signed to do it. They do it now in Virginia and Washington, right. D.C. jurisdictions. I mentioned before at the administrative meeting, the attorney for Washington Gas said we're agnostic to this. If they want to come in, that's fine. So I don't know of any concerns that the utility has with this.
Mr. McGee, let me ask you about the bill you passed out.
Yes.
So this is the bill that indicates a customer is going to transfer from Washington Gas SOS to Washington Gas Light Energy Services. Is that right?
No,
I'm not sure it's 100% to Washington Gas Light Energy Services. It's definitely to a supplier who offers consolidated billing.
Do you know if this is a Maryland customer?
It's one of DECA's customers in Virginia, I'm being told.
It's one of DECA's customers in Virginia. Okay. Do you know what the bill looks like that they received after this final bill from Washington Gas Light?
I submitted a copy last time, and OPC hasn't.
I don't have a copy here. We may have given one to the Office of People's Counsel, or it might be in another packet that was submitted over the summer, but I don't have it. So I'm not sure if you're going for this. I don't know if Washington Gas Light Energy's bill would be as detailed as what we're saying here. We're concerned about what DECA's bill would be, and while arguably we may not have to do all the things that we're doing here, we want to make it clear to the Commission that even uncodified regulations, just directives in an order 15, 20 years ago, make sense to us, and we're okay if you want to adopt them to be very clear to the customer so they know exactly what's going on.
Yeah, we had a lot of discussion about how transparent that all was with our staff and with the Commission. But I appreciate that. I guess what I'm thinking, you kind of are telling us that this is okay, it's already being done, and there's no big change, it's no big deal. But I think when Maryland customers receive a WGL Energy Services bill, I'm surmising, it probably looks very, very similar to a Washington Gas Light SOS bill.
No.
Looks completely different.
Completely different. Yeah, completely different.
Completely
We
different.
have a copy somewhere we submitted. It just says your bill is $94. It's black and white. It's completely different because they're not a utility, so they differentiate themselves.
Okay. Well, so it really highlights all the questions we had yesterday regarding the contents of billing and what's required, what's the required information, and it highlights the fact that it's kind of undefined right now in COMAR. Very well defined, I think, for the regulated utilities, but kind of undefined for consolidated billing suppliers.
So DECA is suggesting that you define it now for DECA, and we've
Right.
laid out the items that were in the previous commission order. We've laid out exactly what we're going to do. You would regulate DECA to that extent, that they wouldn't be a utility, but if they don't do what they said they would do, you'd have the full ability to issue show cause orders or whatever you need to do.
Understood, but wouldn't it kind of make sense for us to define that in a way that we're going to make us consistent with the way we're going to define it for all the other suppliers? Should we issue an order that approves the joint petitioner's filing?
I think there are many, many unanswered questions about implementing this type of activity throughout the whole state. DECA thinks you should go forward and do that and go down that path. But because that it exists now in Washington Gas's service territory, because they're not opposed to this, because their affiliate is the only one that we're aware of that has this type of mechanism, and I'll get to my issues with that in a minute. But I think there are many, many things that are already answered for you and should give you comfort that DECA, the applicant before you, will abide by all these things. And it's something that you can define now, and if there's another supplier that asks the same, you have then a structure and definitions of how they should act within Washington Gas's service territory.
Thank you.
Just a question, maybe kind of a follow-on to Commissioner O'Donnell. You did, looking at the petition and some of the discussion we had yesterday, you do state in your reply that you would certainly comply with any future regulations. It did seem that there were some differences from the petition and the way your business model works now. Do you see any risk in moving forward before we have regulations, supplier consolidated billing regulations on the books that you know exist? If a hypothetical that perhaps they wouldn't mesh with your business model, what would happen then? And would all those Maryland customers now be basically have to be abandoned and returned to WGL? What?
The regulations that exist now, no, because there's not a lot of them, and that's what we're saying that we're going to abide by in our petition of the different rules that are in the order. If your question is really what happens if, based on the petition yesterday, it's granted there's a work group and there's other more stringent requirements, what happens then? The requirement about bonding, it won't be a risk where DECA says, no, I'm not going to go into Maryland, or I'm going to leave Maryland.
A Maryland office, for instance?
He's a mile from the Maryland border, to be honest, so yeah, if that's really what you wanted, that would not be a problem.
Okay, I just was curious to know
right.
if there were any kind of showstoppers in
the only one
we were talking about
yeah,
yesterday.
the only one would be the amount of customers. The proposed 25,000 customers is just gigantic, and it would not, DECA would not be able to do that. I'm not aware of any other mechanism that they could go around. There was discussion about, well, you can contract with a vendor to get the type of experience in billing. DECA has it almost 5 years, not quite 5, but DECA could contract with someone if they needed to bridge that gap. They can't do that to get up to a customer count. And like I mentioned yesterday, to me, it's more how many times have you sent a bill, really, not the amount of customers, but how many times did you have a chance to screw up and that you didn't, and that you did well. And that's the type of analysis I think makes sense to see, are you going to then perform well in Maryland? So if that type of condition can be changed somehow during the work group process where you just have to demonstrate what you've done in other jurisdictions in a different way than purely the number of customers, then DECA should be fine. But if a year and a half from now, you grant the petition exactly how it's filed, let's say in theory, and there's that 25,000 customer number, DECA would need some type of waiver or something to continue in Maryland. So,
Well, Mr. Cleaver, if the commission were to approve the request that DECA has made currently, and then a year from now, the commission does establish qualifications similar to what the petition has suggested, does DECA feel as though it would be entitled to that waiver?
are you talking about just the customer number or
customer
just
number,
in general?
yes.
We would hope during that process that the commission would establish a different mechanism, whether if you wanted to have that full customer number, that there'd be some other grandfather type of clause that would enable them to stay. I mean, no, we certainly wouldn't be entitled to a waiver. That's your discretion to figure out if you wanted to do that. We would just tell you the reality of if that is imposed and DECA does have customers, we just can't meet something like that. And if you chose to then take our license because we can't meet it, then we obviously can't serve customers in Maryland. But we hope it doesn't go to that. So the last thing I want to turn to is the law. And I had referenced a statute and several COMAR provisions about the unfair and discriminatory practice we believe it would be if the Commission does not allow DECA Energy to go forward because an affiliate of Washington Gas is doing this type of practice now. So on page 4 and 5 of the request that I had filed, I cited several COMAR provisions in one statute. The statute's Public Utilities Article 7-604A ultimately protects customers from discriminatory, unfair, deceptive, and anti-competitive acts and practices in the marketing, selling, and distribution of gas. I don't know any other way to put it other than that would be a discriminatory action that the customers would have because they don't have any ability to then choose someone else if they want a flat bill product. They would have to only go with Washington Gas, and they wouldn't have anybody else to choose from if they wanted to get a bill directly from the supplier. They'd have no ability to do that. So allowing an affiliate of the utility to do that and not allow someone else, given all the things we talked about today, we don't think is fair. There are several other COMAR provisions. I won't talk through every one of them, but it talks about the concept of the utility can't give its affiliate any type of discount or preferential treatment over non-affiliates, and Washington Gas does not want to do that. They do not want to give a preference to their affiliate, and they're fine with us coming in here and offering this. But if you denied it, you're in essence requiring them to give preference to their affiliate. Any other questions I can answer?
Mr. McGee, let's talk about 7604 for a
Yes.
second.
Yes.
A says, on or before July 1st, 2001, Commission shall adopt consumer protection orders or regulations for gas suppliers that protect consumers from discriminatory, unfair, deceptive, and competitive acts. I'm not sure that this is a protection for gas suppliers, but it's a protection for consumers.
Right. So the consumers are being discriminated against and are unfairly being treated because they cannot choose someone else other than the utility affiliate to get a flat product like DECA wants to offer, or to get a bill from a supplier if they so choose. So you're right. It is that it's to protect customers. It's regulations or orders for the gas suppliers that are to be used to protect customers. So those are the two parts. And obviously we think DECA is unfairly treated, but for the customers, they're not being protected from that type of anti-competitive practice.
Well, I mean, isn't it possible that what this means is that we're protecting consumers from discriminatory practices of gas suppliers, not protecting gas suppliers from discriminatory practices?
I understand what you're saying. I think they're somewhat one and the same, but ultimately that it's the customer that is not being given any choice other than an affiliate offering the service of a supplier consolidated bill or offering a flat product. So I think maybe we're speaking past each other, but I understand what you're saying, but I think it can also be read to really, we want to protect customers from these type of things. So especially the part of anti-competitive, I can see if it only said protect the customers from unfair, deceptive practices, then we're saying, well, hey, supplier, you can't do these unfair, deceptive things. But we're talking about discriminatory also in there and anti-competitive. And I don't know of a protection that you can put on a supplier to say we're making sure that you're not anti-competitive with a customer. I don't see that. So I think different parts of the statute can be harmonized in a different way to meet both of what we're saying.
Right. I think, I'm not sure whether this particular provision addresses your issue, but, I understand your position as well. Thank you.
Can I ask you a question? I'm not a lawyer, but I got to ask this. Are you suggesting by your citing of the law and the discriminatory nature of an adverse decision to your client means that we can't ever deny an application similar to yours in the WGL territory without violating the anti-competitive discriminatory nature as you characterized the law?
If
We have no basis.
Another supplier came right behind us and they wanted to do the exact same thing that Washington Gas Light Energy is doing, the affiliate. They want to do the exact same thing that DECA is doing under the same terms and conditions that you're going to, if you approve it under your order, and they come and you then deny them, then yes, I think that would fall under that. But that's a very narrow thing that we're talking about.
Doesn't that argument presume that you know what the basis of our denial might be? We may find something in the public interest that would be the basis of denial, and therefore
Right.
you would be incorrect in citing what you cite.
Yes, if you say, DECA, you don't have the experience. DECA, you have many complaints against you, and we don't think that you're an appropriate supplier. Sure, you're absolutely right. You could have parts of your decision, but assuming that DECA's a good actor and it's really just about the stuff we're talking about today, I think, yeah, you would have a precedent you'd have to follow, but you can certainly find other reasons for a particular supplier to say, we're not approving what you're filing. It is not in the public interest. That makes sense.
I wanted to make that clear for the record. Thank you.
Sure.
Anything else from Mr. McGee or Mr. Sergi? All right, if not, gentlemen, we appreciate you coming back and making your presentation and answering our questions. We're, as you know, in the middle of our supplier consolidated billing hearing, so we're not going to make a decision here on the bench, but we will take this up, as quickly as we can, because I know you've been very patient looking for a order from us. So
Understood.
We will get back to you as quick as we
Great,
can.
thank you. And we think it's perfectly reasonable for you to wait until all of the information you heard yesterday. That made sense. It enlightened me on a lot of issues, and hopefully today we gave you information that helps you distinguish between the two tracks. So thank you very much.
Thank you. That concludes our administrative meeting. We will be back at 11 o'clock to continue our supplier consolidated billing hearing. Now we are adjourned.